just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
This is not a clown show. Plaintiff admitted that too. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion.
That sounds like an absolute train wreck, in the most entertaining way possible. Sovereign citizens always bring a special kind of chaos to the courtroom, but when they go up against a judge who has zero patience for nonsense, pure gold. Was there a particular moment that had you in stitches? Like when the judge asked him a simple yes, no question, and he responded with a 5-minute rant about admiralty law? Or when he accidentally admitted guilt while trying to argue he wasn't subject to the court's jurisdiction?
First, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. By open written discovery in this matter, you have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor,
you don't want to accept
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst, I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you.
Oh, this dude is fully committed. Whether it's delusion or just an Oscar-worthy performance is the real question. I mean, at this point, he's either convinced himself he's cracked some secret legal code or he's doubling down just to save face. Either way, watching him get verbally body slammed by the judge is chef's kiss perfection. The best part? He really thinks he's dropping some courtroom mic drop moments, like he's about to walk out a free man while the judge just rolls their eyes, probably thinking, another one. You can tell the judge has a personal speedrun record for shutting these guys down. What was the peak moment for you? The I do not consent speech. The I'm a free citizen, not a person nonsense. Or when he somehow managed to incriminate himself, mid-rant.
You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
Oh, this guy definitely thinks he's playing 4D chess while the judge is just speedrunning his inevitable downfall. The way he's strutting around with that misplaced confidence, convinced he's found the ultimate legal loophole, when, in reality, he's just racking up more contempt charges, is pure entertainment. The return to sender strategy is next-level delusion. Like, does he think the court system works on Amazon's refund policy? Sorry, Your Honor, I sent the letter back, so legally, I'm not responsible for any of this. My guy really believes he can reverse a criminal charge. At this point, I think it's a mix of both. He's somewhat convinced he's right, but also putting on a show because backing down now would be admitting he's in way over his head. The judge, though, ice cold, waiting for the perfect moment to drop the final gavel slam. You know it's going to be a glorious reality check. What's your bet? Does he double down one last time? Or does he finally realize he's cooked the second the verdict drops?
The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
This was an absolute masterpiece of self-destruction. The guy practically walked into court, handed the judge a signed confession, and said, "Your Honor, I rest my case." Like, was he trying to set a world record for fastest unintentional admission of guilt? Because, if so, congratulations, mission accomplished, and the PowerPoint analogy. Spot on. I can just picture him with a slideshow titled, "Why I Am." Above the law, flipping through slides of legal nonsense while the judge sits there thinking, "I've seen toddlers with better defense strategies." The best part? The judge warned him. Gave him every possible chance to stop making a fool of himself, but nope. He doubled down, tripled down, probably took out a mortgage on that bad decision. Honestly, I think he's both clueless and putting on a show, like he's convinced. He's cracked some secret legal hack, but at the same time, he's so deep into this act that even when reality slaps him in the face, he refuses to break character. Either way, it's been pure comedy gold from start to finish. So what's your favorite part? The self-snitching? The refusal to take free legal advice? Or the delusional confidence that somehow stayed intact even as the walls closed in?